In the business world, when people talk about employee theft, they often speak about the legal rights of employees and the need for employers to follow various procedures when terminating an employee. Rarely, however, do they speak about the need for the retention of an industrial security firm to assist an employer in stopping the actions of an errant employee and prove that the employee is guilty of theft. This is unfortunate because each year U.S. companies lose billions of dollars due to employee theft, and these numbers are growing. Large companies have their own security forces, but many small firms simply cannot afford such protection. The service industry today is filled with firms whose entire business strategy is geared towards assisting private sector employers. One such type of firm that is often overlooked forms the base on which private business can be conducted in a profitable manner. This sector of the service industry is industrial security and investigations. Industrial security firms operate on many levels throughout the private sector and offer a wide array of services. These services are broken down into two distinct groups: preventative and investigative. Firms that emphasize preventative security measures can offer services such as pre-employment screenings, background and criminal record checks, CCTV and monitoring device installation, termination assistance, computer and electronic monitoring, security consulting and advisement, RFID and integrated security systems, biometric security installation, employee surveillance, and theft investigations. In the business world, one can generalize employee theft into the Pareto principle, which means that 80% of an employer's theft comes from only 20% of the company's employees. Eliminating or preventing the 20% of employees from stealing can greatly increase profits and alleviate shrinkage. The reason that preventative measures work so well is that in a normal workforce, the following often proves to be true. 40% of employees have strong and ethical morals and will not steal. Another 40% of employees are fence-sitters with no overt intention to steal, but given the opportunity, will steal. And the last 20% of employees are purposefully and diligently attempting to steal from the company. Firms that specialize in investigative security offer services such as personal surveillance, GPS tracking, hidden cameras, workman's compensation investigation, insurance or workman's compensation fraud, property searches, VST testing or voice stress testing, information development, personal security including bodyguarding, and consulting and design services. Investigative security helps deal with pre-existing shrinkage or loss. If a company is experiencing high amounts of shrinkage or has suspicions of theft regarding employees, investigatory services may be in order. Along with theft are employee accidents or personal problems. Drug or alcohol abuse before or during work can lead to excessive accidents and property damage, leading to increases in cost. A private investigation firm has many resourceful tools at its disposal to obtain information or proof of theft, ranging from low-tech footwork to the high-tech devices listed within the hypothetical investigation. The hypothetical investigation goes as follows. Engineering Incorporated of West Michigan, also known as EI, a small engineering firm, was in the process of bidding for a government contract that was worth approximately $30 million. The firm had recently lost a large contract opportunity to another firm, and afterwards the CEO of EI was surprised to find out how similar his company's designs were to the company that won the bid. The CEO began to become suspicious that one of his employees was stealing the information from the firm. He was concerned that if his suspicions were accurate, the firm could lose yet another large contract because of theft of trade secrets by an unscrupulous employee. The firm had a central computer located within their office that held all of their privileged information. The centralized computer had only one door accessing it, and the computer was located in the middle of the building. The firm had simple preventative security already in place to protect this data. Two security measures monitored the only access point to the building. The first measure was a radio frequency identification or RFID proximity card system that logged employee numbers into a centralized database. The second security measure was a stationary closed-circuit television camera, also known as CCTV, that was focused outward towards the main entrance. After overviewing the proximity card readout in the CCTV camera system, EI isolated one suspect who routinely entered the building after hours. EI acted on its suspicions and contracted a private industrial security firm named Industrial Security Firm, also known as ISF. After an initial meeting discussing the facts of the case listed above and EI's expectations, ISF signed a contract with EI and began its investigation. Initially, a keylogger was installed on the suspect computer along with a hidden camera pointed at the computer. Also, a background and criminal check were conducted on the suspect. Full-time surveillance was started on the suspect, and a global positioning satellite, or GPS, receiver integrated into a tracking system was placed on his company car during work hours. The GPS locator was attached to the muffler of the vehicle by use of a magnetic strip. Then, once the car had been started, the tracking system was activated from the heat of the exhaust. When the suspect employee left work after hours, a team tracked and monitored the employee to his destination. When the employee arrived at his destination, an outdoor cafe, the team set up positions out of direct eyesight and entered on foot to obtain a better view of the suspect. During the investigation outside the cafe, the suspect was witnessed and recorded handing over a red thumb drive containing EI's stolen trade secrets. After the meeting came to a close, the chase team broke off from the employee. They relied heavily on the GPS tracking system to monitor the employee's movements and followed the new contact to his home via the use of an online mapping program such as Google Maps or MapQuest. Once the team arrived at the new contact's home, they continued surveillance throughout the night. The next morning, the team recorded the new contact leaving his home and proceeded to the Thieving Corporation building. Now that the surveillance team knew the name and location of the Thieving Corporation, the surveillance team decided to have one of ISF's employees hired as a temporary employee in order to obtain additional information. ISF also decided to take the company's trash from their unlocked dumpster that was located in a public parking lot. ISF subsequently exhumed all of the trash from the thieving company's unlocked dumpster. The surveillance team found a copy of a check invoice for the thieving EI employee in the trash for $2,500. The information obtained from the surveillance clearly established that the suspect employee was selling confidential information to this thieving company. All of the information obtained by ISF was then compiled into a report and handed to EI. It was then up to EI to determine whether or not to contact the prosecutor to file criminal charges and/or file a lawsuit against their employee and the thieving company for theft of trade secrets. After the report was compiled, recommendations for a more comprehensive preventative security system were issued to ensure that information would no longer be lost. A more overt CCTV system that will help deter thieves, biometric access to the centralized computer with time locks to prevent inappropriate access, a change in the access to print and file sharing so that access would require authentication from an upper-level manager, a requirement that employees not only sign confidentiality agreements, but also sign waivers that acknowledge the right of the company to legally utilize all tracking and recording devices available when employees are using company cars, phones, computers, and any other technological devices owned by the company. Provide a physical security guard on the property 24 hours a day to secure any areas not covered digitally. No security system is flawless, so this human presence ensures that all the equipment is operational and performing correctly. Also, the presence of a guard 24 hours a day deters would-be criminals. As the hypothetical suggested, the employee used an RFID prox card to gain access to different locations throughout the building. Currently, there are no federal statutes that provide limitations to private employers on the tracking of employees through the use of RFID devices. However, some states now recognize the privacy infringement issues that RFID technologies could raise. As of 2007, California, North Dakota, and Wisconsin have each banned companies from forcing the implantation of RFID microchips into their employees' bodies. In reference to the computer surveillance and hidden camera or CCTV technologies used in the hypothetical, the Electronic Communications Privacy Act of 1996, otherwise known as the ECPA, provides some limitations on private sector employers' ability to electronically monitor their employees. In basic terms, the ECPA prohibits employers from the intentional and simultaneous interception of any electronic communication that is transmitted through a wire. However, through the use of 3 employer exemptions, the ECPA does not completely prohibit employers from electronically monitoring their employees. In order for employers to show that their employees have given prior consent to electronic monitoring, they should create a company-wide policy explaining what activities will be monitored, or they should have their employees sign a monitoring consent form. The second exemption is offered only to employers who use surveillance and electronic monitoring for strictly business purposes. According to this exemption, as long as employers can show a legitimate business reason for monitoring employees, such as increased productivity and reduction of inventory theft, then the ECPA does not apply. The third and final exemption to the ECPA is the systems provider exemption. Although this exemption does not directly apply to the hypothetical, it is important to note because it bars most private sector employees from protection under the ECPA for two distinct reasons. The first reason is that the ECPA only applies to interstate communication. Employers who provide an intra-company email system whose messages do not cross state lines fall outside the protection of the ECPA. The second reason is that courts historically have failed to recognize most private employers as systems providers. In conclusion, as long as employers can prove a legitimate business reason for their surveillance, the business use exemption to the Act allows employers to use such electronic surveillance technologies as key logging, point-click detection, and hidden camera CCTV technologies. In the hypothetical investigation, the employer had installed a GPS tracking device on the company car which the suspected thief was operating. In regards to the GPS tracking of employees while driving company automobiles, the fact that an employer may use GPS technologies to track the location of their own vehicles does not constitute a highly offensive intrusion upon the seclusion of the employee who may be operating the vehicle. In fact, the U.S. Supreme Court stated that an employee traveling in an automobile on a public road has no reasonable expectation of privacy in his movements from one place to another. Therefore, the employer in the case study was legally permitted to install the GPS tracker on the company car which the employee was driving. In regards to dumpster diving, the courts have ruled that any garbage which has been deposited in a public area and is ready for removal can have no reasonable expectation of privacy. With this in mind, employers should create a company-wide document shredding policy that clearly states and describes to employees which documents should be shredded in order to avoid both personal identity theft and theft of trade secrets. Just as in the hypothetical situation, it is common for private investigators to follow a suspect by tailing their vehicle. However, many states have anti-stalking laws that dictate how and to what degree private investigators can properly conduct manual surveillance. Since the hypothetical situation involves a Michigan-based company, a quick look at Michigan law states that an activity is classified as stalking when an individual follows or appears within sight of another individual on two or more separate occasions, and this activity causes the other individual to feel intimidated, harassed, or molested. Therefore, so long as the investigator remains undetected by the suspect, the manual surveillance cannot be considered stalking within the context of Michigan law. Typically, employees can assume that they have an objective, reasonable expectation to privacy of their private office areas and the belongings that are located within the specific area, so long as the office and the belongings are not shared with anyone. However, employees do not have a reasonable expectation of privacy in open work areas, unenclosed locker areas, or desks, files, and the like which are subject to shared access among employees. Therefore, in the hypothetical investigation, the employer's use of a hidden camera that was fixated on the computer from where they believed the employee was obtaining the trade secrets is legal. In today's highly competitive business environment, protection from theft of intellectual property as well as physical property should be a top priority. A 2002 report from the U.S. Department of Justice found that in over half of all intellectual property cases, the stolen information was worth more than $70,000. Of course, this number pales in comparison to the estimated retainer of approximately $7,000 for the security services that are given in the hypothetical. Perhaps the most important factor in contracting an industrial security firm is whether it is within its legal bounds to operate by having a private investigator license. However, with the absence of federal statutes on the topic, each state has varying qualifications to become a certified private investigator. Companies also should only hire an industrial security firm that is affiliated with either the American Society for Industrial Security, also known as ASIS, or the Association of Certified Fraud Examiners, also known as ACFE. ASIS is the world's largest organization for security professionals with over 36,000 international members and a wide variety of services to help aid security professionals. The ACFE is an organization aimed at lowering fraudulent dealings within the business world. They release a yearly report to the nation overviewing annual losses from fraud and have a large and extensive database on all materials related to fraud in the workplace. Industrial security firms that have established memberships with ASIS or ACFE are likely to provide customers with a list of references so that they may check out their quality of work and their level of professionalism. The bottom line is that companies whose survival hinges on intellectual property should take the proper preventative measures to safeguard their valuable trade secrets. Therefore, it is highly recommended that companies hire a properly licensed industrial security firm to install any necessary security devices prior to any theft. In addition to an upgraded security system, employers need to also be proactive in obtaining surveillance consent forms from employees in order to avoid any possible legal ramifications. Although designing and installing the proper security system may seem expensive, it is well worth it to protect any trade secrets that, if in the wrong hands, could destroy the company.